And joining us now is the Chief Justice of the Supreme Court of Canada, Beverley McLachlin. We are very honored to have you here in TVO tonight. Thanks so much.
Thank you. It's a pleasure to be here.
I guess the first thing I should ask you is, what am I supposed to call you?
You can call me a lot of different things. Most people call me Chief or Chief Justice to my face in any event.
Okay, we'll go with that, Chief Justice. I'm happy to do that. Let's just put a little bit of background up here for those who don't know much about you. For example, you were born in Pincher Creek, Alberta. Called to the Bar of Alberta in 1969 and the Bar of British Columbia in 1971. In 1988, you were appointed Chief Justice to the Supreme Court of BC. 1989, appointed to the Supreme Court of Canada. And then in 2000, appointed Chief Justice of the Supreme Court of Canada. And you are, of course, the first woman ever to hold that position. So let's start with a little sort of Civics 101 here. How are you appointed in the first place?
Judges are appointed, I'm talking about federally appointed judges now, by the Prime Minister, by Cabinet. Order in Council is the technical word. So it's basically appointment by the government.
So does Jean Chrétien actually get on the phone and call you and say, Madam Justice, we'd like you up here in Ottawa instead of...
Absolutely.
So you spoke to him on the phone?
Yes.
And how does that conversation go?
Well, usually there's been a little bit of preliminary vetting. Someone will call you from the office to say, if you were asked, would you be interested, what would you say, would you be interested in serving? And so at that point, you ask for a few minutes or an hour or a day, and you think about it, and then you get back. And then at a certain point, they set up a call.
But it's a done deal by that point.
Pretty much. I mean, you never know. There are stories that people have been approached and they never got the call, that kind of thing. So it's not necessarily until that final ink is on the paper, and presumably when the Prime Minister calls you. And for appointments to other courts, it might be the Minister of Justice. But usually that, one would assume, would be a done deal.
So you were appointed in 1989 to the Supreme Court of Canada.
That's correct.
Does that mean Brian Mulroney made that phone call?
That's right.
Okay, and so you said yes to him, and then Chrétien calls you and says, do you want the chief job?
Yes.
And how long did it take you to answer that one?
Not very long. I was very happy to accept. I really was. For me, it was a great honor. I mean, there can't be any greater honor in the life of a lawyer or the life of a judge than to be asked to be the Chief Justice of the Supreme Court. So it was also something that I thought I would be very interested in giving my best shot at. It's such an important and interesting job, so I was absolutely delighted.
Was it a big deal for you to be the first woman to have this job?
Well, in a way, but you know, personally, how I would feel about it, at that stage in my career, I think of myself as a jurist. I've been on the Supreme Court of Canada for 10 years. I'm not thinking so much in terms of I'm a woman or a man. I'm just a judge of the Supreme Court of Canada. I'm a jurist. So, frankly, in terms of what goes through my mind at the initial point, it's not so much colored by gender, but of course one sits back and one realizes this is really significant for me, but also I think for our country that we would consider having a woman at the top post in the judiciary.
Does it really make a difference to how decisions are made in the court depending on the composition of men versus women, older people versus younger people, all of that stuff?
I think it does in the broad sense that you want to have a court that's coming from a lot of different backgrounds. You want to have different perspectives. So you want a diverse bench. You want it diverse in terms of gender. We have diversity in terms of regions. Our judges come from all over the country. And every judge brings their own perspective. So we work as a group, but we're a group of individuals talking to each other. So I think it matters, yes.
What about the job of the Chief Justice compared to the other 8? What do you get to do that they don't?
I don't have any more power, I can tell you that, because my vote counts for the same as anyone else's. And I continue to sit as a justice, which I think is very important. Mm-hmm. But in addition, the Chief Justice has certain administrative duties.
But do you get to say, we'll take this case, but not that one?
No.
You don't?
No.
Do you get to say who gets to write the decision? This guy, not that guy?
I do, because my colleagues consent. They came to me and said, would you do this? And because it's simply an efficient way of getting the work done. So I do undertake that responsibility.
So are you really kind of a first among equals? You really are?
That's what the saying is, first among equals, pari inter pares, to use the Latin phrase.
Let's go through what a typical day is like for you.
Well, first of all, I have to say that a lot of days aren't typical. But let's take a day when I'm sitting in court, which would be 2 weeks of every month, except for the summer months when we don't sit. We just work on our judgments during that period. But I get up around 6:30, 6:45. I go for a walk with my dog, try to get some exercise. I have a little breakfast. I go to the court. I probably have a meeting or two with our registrar or with someone else about administrative matters. I do a last-minute read of the documents, which I have prepared completely. We prepare all the cases in advance, but it's always nice to look at the last minute, and just because you've been thinking about the case that's coming up and you maybe want to check something or do something. Then I go into court, I gown, as do all the other justices. We hear the case. After the case, we have a conference in our conference room.
So this is all 9 of you all the time?
Not all the time, but usually. Most cases are heard by 9, some are 7, very rarely 5.
Okay.
And after that, which can take us up to lunch, it can take us beyond lunch, depends how long the case is. Hopefully, I get a little time in the afternoon to work on a decision, to do some preparation for the next day's case, to think about it some more. Maybe I'll have a chat with a law clerk or another justice about it. There may be some event in the afternoon or evening that I have to go to. Often they're judicial events, legal events where I have to make an appearance.
It sounds like you do. Is it one case a day? Would you hear
Generally.
that? Really?
Occasionally we hear 2 a day, but usually it's 1 a day.
So there's no monkey business. The lawyers have got to go. They've got to be very efficient in the way they present. They can't go on and on and on.
We have, for the most part, time-limited hearings, and we generally allow an hour to each side. We have interveners on many cases as well, and they're given 10, 15 minutes. So the case can vary in length. And there are cases that go 2 or 3 days if they're very complex or groups of cases clustered together.
Now, our assumption is that the 9 of you sort of get into one room and hash it out. Is that how it really works?
Yeah.
It does?
Yeah. We get out of our court hearing, which I described a moment ago, and we go into our conference room and we sit at a round table. And usually we have a period when we just chat about the case. And we might go issue by issue if there are a series of issues. And what do you think about this issue? And people pitch in. And their views at that point may not be entirely decided. But they're saying, well, what about this? And I think that. And isn't this important? No, you're not right on that. You've made an error. You know, we're very, very frank.
Do you yell at each other ever?
No, I don't think so.
Never any raised voices?
No, I don't think so.
Would you tell me if there were?
There aren't. It's certainly there can be tensions because different people will see the problem different ways, but that's a very healthy tension, and we're used to working that way. Then after we've had that sort of round, initial go-round, free-for-all, if you want to call it that, I go around and I start with the chairperson starts with the junior judge, and then we go around and each person summarizes their position at that time. That doesn't mean that that's the end of it. We'll still be thinking about it, and we can change our minds, but that's an indication of what we think at that time.
Now, why is it the case that you may hear something in January, but we may not hear about your decision until like June?
Good question. I wish it were quicker, and often it is quicker. There are cases that come out within weeks. There are some that are actually given from the bench. But the fact is that there's a huge amount of work that goes on, particularly in the more complex cases. First of all, the decision has to be written, and that can take some time. Now, we strive for consensus insofar as we can achieve it. The right to dissent is highly prized and respected, but we don't like to dissent for nothing. So we work to try to minimize our differences, and we're quite successful.
You'd love 9-0 on everything,
yeah,
obviously.
Well, I wouldn't go that far, but there is a view that dissents provide seeds for future developments, and it's a very healthy thing in the jurisprudential system. But first of all, we're writing the decision, then we're making memos about it and having discussions about it. We're changing it, we're altering it. Maybe there's a dissenting opinion that comes out. So all that takes usually 3 months or more. And then after that, we have to edit the decision because it's going to be published and so on. And we have to translate it.
Sure.
Because our court functions fully bilingually. So we have to translate it. And all of that takes time. And we have a staff of legal editors and translators. And then finally, at the end of the day, we schedule it for release.
Now, you, of course, as not just the Chief Justice, but as any judge, have to be seen as being very neutral by the broader population.
Absolutely.
And I'm wondering, as a result, how much of normal life do you have to cut yourself off from in order to keep that image of yourself?
Well, you know, I've been a judge so long that normal life for me is acting like a judge. So, but I think judges now are less closeted than perhaps they were 30 years ago. I go to plays, I go to the symphony, I can go to movies, I shop in the grocery store like everybody else. I went to a hockey game last week with my husband, and
can you cheer for the hometown team?
That's a secret, but yes, I think you can.
Well, I know you're from BC, so you're probably a Canucks fan.
A long time ago.
but here's, I mean, this is a bit of a silly example, but it's not beyond the realm of possibility that, for example, the Ottawa Senators may have an issue before your court someday on some who knows what kind of issue.
It could, and it's very unlikely. And in the event that something I had done had indicated too great a love for the Ottawa Senators, should there be such a thing, then I think I would have to recuse myself. But we have ways of doing that too. But this really doesn't happen very often.
Well, how about this as a hypothetical example? Your court, same-sex marriage, for example, which of course a huge debate in the country about for many, many years, and now of course it's allowed. Could you show up at a Gay Pride Day parade, for example, or would that be seen as being kind of too sympathetic to one side of that argument?
Yeah, I don't think a judge would do that. I think we try to watch out for things that are issues that could come before the courts, and we don't want to either take a stand or be seen as taking a stand on those issues. As you said at the beginning of this question, we have to preserve not only our actual impartiality, but the appearance of impartiality. So we try to avoid getting involved in anything contentious in the community. So that is a limit.
Let's go to our final segment here, which I'm calling Let the Sun Shine In, because I remember when I approached you to do this interview many, many months ago, I pitched it on a kind of you're one of the most important institutions we have in this country, and we know so little about you because, as a general rule, judges don't give interviews, and they certainly don't have press conferences after they release their decisions to answer reporters' questions and that kind of thing. Do you think judges, generally speaking, are concerned that the public doesn't have a very good understanding of what they do or how they do it?
I think so, yeah. I think that this is perhaps a relatively recent thing, but we recognize in the judiciary that we serve the public and that we are an important institution, and that it's important that the public understand the work we do and how we go about it. And so we're quite happy and ready, which is why I'm here today, to discuss our work and tell Canadian people this is what we do, this is how I think Canadian people are entitled to know that.
You know, of course, when somebody's nominated by the President to be on the Supreme Court, they have to get the advice and consent of the Senate, and they go through, boy, they go through some pretty tough hearings.
Yes.
And now, we've had no high-tech lynchings up here, as far as I know, but should we have a kind of tougher vetting process for the jobs that you have before, for example, a parliamentary committee?
I think our process is working pretty well, and so I guess my answer would be no. That's my opinion. Other people might have other opinions. I think most people who know the Supreme Court of Canada well would agree that we don't have a marked right-left syndrome. We don't have judges on the court who are identified by political stances. We are much less political in that sense than some people suggest the American courts are. And I think that's a good thing. And the absence of politicization of the process, I think, has permitted prime ministers and cabinets over the years to simply say, who's the best person from the part of the country that we are looking for a justice of the Supreme Court from? So history, I think, shows it's worked pretty well the way we do it. There's a danger if you get politicians involved, parliamentary hearings, Senate hearings, whatever it might be, that committee can break on party lines and that you bring political considerations into the appointment. Now, it's up to every citizen, I suppose, to decide whether that's a good thing, but there are a lot of people who don't think that that is necessarily good in a judiciary. A lot of people think we should not have a politicized judiciary.
What's the most important skill someone like you needs in her job?
Well, I suppose there's a lot of skills one needs, but the basic thing is that you have to be a good judge. You have to be a good jurist. That's the most important thing. You have to be able to deal with the law, with legal traditions, with legal cases. And added to that, you have to have judgment, whatever that is, that elusive quality. But you have to be able to look at a lot of data, a lot of things, a lot of conflicting arguments, and come out, you hope, with a sensible answer, one that makes sense not only in legal terms, maintaining the rule of law, the legal traditions of the country, but that will make practical sense to the parties, the men, women, corporations, whatever, who are before the court and the people who will have to apply that law in cases to come.
So people skills, communication skills are less important than really just living, breathing, eating, understanding the law.
Well, you asked me the most important, and I always hesitate at these questions of what is the most important, because you really need a package to do this job well. And I think people and communication skills are very important, particularly communication in writing, because we have to write our decisions in a clear and lucid and helpful way.
Let me ask you one last thing, and that is, looking at previous Supreme Court judges in this country or south of the border, which one was the singular influence on you?
Well, honestly, there was no particular person. I've been influenced, though, by many great judges, and it's invidious to start naming them, but I won't say anything about living people because I would really get myself into trouble. But for example, when I came on the court, Brian Dixon was the Chief Justice, and he was, in my opinion, a great judge, and probably influenced me. I hope some of his good sense and wisdom have rubbed off on me in any event.
And I lied. One last question. Who'd you vote for in the last election?
I'm not answering that. I actually don't think I did vote. I try to, personally, I did not vote. I try to stay out of the political process. Now, I'm not suggesting that judges shouldn't vote. They have been given the right to vote, and I think that that's perfectly compatible with judicial office. But I just chose not to. I felt more comfortable not voting. That's a personal decision on my part.
Because if anybody sees you walking into a ballot box, they're going to think, is
Well,
that
they
why?
wouldn't know how I voted, I don't suppose.
No,
so.
but they know you'd favored somebody. And you don't want to give the impression that you favor anybody.
Yeah, I just feel more comfortable not voting. Now, I'm not suggesting that it's improper for other judges to vote at all. I think the view is now that there's nothing wrong with it. But that's just my personal preference.
And judges can hold their jobs for how long?
We hold our jobs on federally appointed judges until 75.
Oh, so you got lots longer to go.
Yes.
I know how long, but I won't say. Madam Chief Justice, it's awfully good of you to spend some time with us at TVO tonight. Thank you so much.
Thank you so much. It's been a great pleasure.